Turn of the delegation to respond again to the questions that we have just raised. And so without more ado, I turn to Dr. Banda, the distinguished head of the delegation, to direct the process of responding. You have the floor, ma'am.
Thank you, Mr. Chairman. I must confess that the meeting we had for 15 minutes was a marathon one, but we'll try to respond to as many questions as possible, deriving comfort in the fact that there will be follow-up questions if we miss out other questions. So I'll start with the question about the legal aid issue and also relating to pretrial detention. I think there was a concern that is rampant in Malawi, and there are also high legal fees. People cannot afford to hire lawyers, and the legal aid state institution is underfinanced to be effective. So the issue is whether government is putting in place any measures to deal with these issues, these concerns. Among the measures that government has taken so far includes the passing of a law to change the legal aid department into a standalone institution called a bureau. The whole idea is that in that state, it will be able to access other sources of funding in addition to government funding. So it will empower or enable the legal aid to access finances even from development partners as it is directly. That is to boost its finances. Government has also, in that act, introduced a kind of partnership arrangement with civil society, where civil society bodies will be required to sign MOUs with the legal aid to complement the work of the legal aid. They have to be accredited and then provide legal aid services, especially in the districts, because the legal aid is only in the 3 towns or regions of the country's capital districts in the regions like Lilongwe, Blantyre, and Zuzu. On top of that, government has also improved the remuneration of lawyers working in the legal aid, just to make it attractive to perhaps private practice lawyers. It has also entered into a partnership with the Irish Aid, which are providing pro bono legal aid services to clear backlog at pre-trial stage. They are in their prisons in Malawi looking at case dockets and trying to move them. Where there's need for bail applications, they will do that. Where there's need for prosecutions to be expedited, they're also working on that. Additionally, we have also reviewed the Legal Education and Legal Practitioners Act. There's a bill that has liberalized the legal profession in Malawi to allow people working trained in other jurisdictions which were not initially previously permissible to practice law in Malawi, just to broaden the pool of lawyers that can practice in Malawi, and also in the hope that most of them can also find their way to the legal aid state institution. So these are some of the measures that government has put in place to try to address the challenges faced by the provision in terms of provision of legal aid in Malawi. I also move on to other very quick other questions which I think require very quick answers. There was the issue of the criminal responsibility, age of criminal responsibility, whether the age has been raised. The age was raised from 7 to 10 in 2010, so that was done. In terms of the capital case, the former chairperson of the Human Rights Commission, the prosecution, I'll only refer to the outcome. The prosecution was dropped, but we're also aware that he commenced a private suit suing government for compensation. So that's the outcome of that matter. In terms of the reports of the Inspectorate of Prisons and Human Rights Commission, I think the concern was whether these are in the public domain. Of course, they're laid in Parliament, and once a document is published and laid in Parliament, it's in the public domain. People can take government officials to task on any matters or recommendations that have been made in that act. There was also the question about the Education Act. That act was enacted in 2013, is now part of the laws of Malawi. This is the law that is incorporating the issue of compulsory education. But whether we can enforce it, I think that is another matter, but it's a new act. We'll see how it gets implemented as we move around, taking into consideration the socioeconomic conditions in the country. Having replied to those list of questions, we move on to the issue of the Rastafarians, and I'll ask my colleague, a member of our delegation, Mr. Chizaso Nyirongo, to respond to the issue of the rights of Rastafarians in Malawi.
Thank you, Chair. I think in Malawi, the issues to do with religion, belief, conscience are entrenched in the Constitution, and actually they are quite heavily entrenched because these are provisions which cannot be derogated from under no circumstances, and there can be no restrictions or limitations to these rights. And the government has taken note of the concerns from the Rastafarian community and even gave an audience with the Office of the Attorney General to hear their concerns so that they can actually be responsive. So since the meeting which took place earlier this year, government is now trying to strategize to find out how they can actually start addressing these concerns. There are social challenges because the issue of acceptability of Rastafarians, whether in employment or in education, goes beyond public institutions. So government is trying to work out how these matters can be resolved and addressed so that Rastafarians can actually enjoy their rights with respect to religion or belief and conscience. Thank you.
The other issues was to do with child labor and exploitation. I think the concerns were the contradictions in the child labor age and whether the government responses to these concerns and the measures that have been put in place, and also in relation to the children living in the street. I will defer back to Mr. Nyilongo as to how this is being addressed in Malawi.
Okay. With respect to the issue of child labor and exploitation of children, this is a matter which government is aware of and has taken note and is actually trying as hard as possible through the Ministry of Labor to address these challenges by actually addressing the people who actually recruit and employ children. We have got issues with the issue of age because indeed government is aware that some children who are really young have also been engaged in employment which is not commensurate with their age because they are engaged in actually heavy labor or sometimes even exploitative labor. So what government is doing is to actually look at how the provisions of the law can be enforced. Of course, taking into account the other socioeconomic challenges which exist, because in Malawi we still have child-headed households, and that there will be other households which are possibly headed by a single parent, and that there's need for at least some of the children who are mature enough, they can participate in an economic activity which can support the family. So government is trying to actually make sure that the provisions of the law as provided are enforced. Well aware that the definition of childhood varies depending on context in Malawi. So you find that, for instance, under the Penal Code, which also protects children from exploitation, will recognize children as persons under the age of 16, but within the specific context of labor, that's where the exception is made that children are recognized as persons who are up to the age of 14 because of the socio-economic environment within which Malawian children grow. But the Ministry of Labor has actually commissioned research on this matter to find out exactly how extensive the problem is, especially within the industries which recruit lots of children, so that they can actually begin to monitor and ensure that if at all children are engaged in labor, they are falling within the permissible age, and that the conditions under which they work are supposed to be protecting them and making sure that they are also able to realize other rights beyond economic rights through employment, they are able to attain education and pursue other goals and ideals. Thank you.
Thank you very much. We now move on to the issue of the public broadcaster, whether there are any initiatives to improve its independence, and also the issue of access to licenses. Before I call upon my colleague, Mr. Pacharo Kaira, to respond, I wish to mention, I think there was an issue of the e-bill, just to mention that this is still a live bill. It has gone through a lot of consultations. It hasn't died. It's still on the table. It should be going to cabinet any time, because I know that the Minister of Justice is working with the Department for E-Government to finalize and perfect the bill in view of the consultations that have been going on for the past year or so. Mr. Pacharo Kaida on the public broadcaster and the issue of licenses.
Thank you so much, Chair. On public broadcasters, the recent or current statistics we have show that there is a total of 77 broadcasting licenses which have been given by the regulatory authority. And out of those 77, about 16 of them are to private television stations. Out of 77, 16 are to private television stations. So that's the answer I would give in terms of access to licenses. On the public broadcaster and its freedom and from interference from the government and its independence, throughout the years previously, this has been a challenge, and I think our report has acknowledged that aspect. However, we wanted to update the committee that we have faced changes as far as the independence of the public broadcaster is concerned, and a classic example is how the public broadcaster behaved during the just recently held tripartite elections in May. The broadcaster was very independent, and I think this was acknowledged by both the Electoral Commission as well as international observers who came to observe the elections. So while this has been a challenge previously, we're glad to report that we have had changes such that the public broadcaster is free from interference. Thank you very much.
Thank you. There was also the issue of initiation ceremonies for girls and what measures government is putting in place to arrest this development. Just to mention that recently government adopted a policy on a national policy on girl-child education, and the objective is to keep the girl child in school. And there are certain measures, and I think there's a strategy that the Minister of Gender and the Minister of Education in conjunction with the Minister of Gender are working on to ensure that girls stay in school as a bid, I think, to try to arrest or to redress this harmful practice that is happening in Malawi. The other issue that was raised, I think, was the question of whether there is no spousal rape in the country. I would defer to Mr. Nyirongo to respond on that in the context of law reforms in Malawi.
I think, as mentioned yesterday, Chair, the issue of spousal rape has come up for legislative intervention several times. I think the most emphatic effort was through the development of the Prevention of Domestic Violence Act. That's where I think it was thought that it would be properly situated so that it can be addressed. But when the Prevention of Domestic Violence Act was enacted, that matter was not part of the provisions under the Prevention of Domestic Violence Act. But I think the state machinery is aware of the problem and is actually now trying to respond. The matter came up again, I think, for debate through two programs that the government was dealing with under the development of the law on marriage and also on the Gender Equality Act, to see if that matter could also be addressed. But I think through the consultations that were done during these processes, the Commission concluded that this matter should not be included, but should be examined, I think, as an issue to see if it can actually be introduced as a legislative intervention and under which statute it would be appropriate, taking into account the concerns and the discussion amongst the stakeholders with respect to this issue. So as it stands, it is not regulated by statute, so there's no provision which actually regulates statutory rape, although rape still exists as an offense. And there are other circumstances, like under the marriage law, it is being proposed that if people are married but under separation, then rape can actually occur. That is a proposal under the Marriage, Divorce and Family Relations Bill. But as you know, that law has not been enacted yet, and perhaps that would be an entry point for introducing spousal rape, depending on the discourse and the discussions that will surround the issues of rape in matrimony. Thank you.
The other issue that was raised by your committee, Mr. Chair, related to the provision providing for searches without a warrant. And I think there was an issue that was raised that it had political undertones. So, I wanted to correct that because though this law was passed recently, it was as a result of a highly consultative process by the Law Commission, which was done in the early part of the 2000. I cannot recall at hand when, but I think it was either 2002 or 2003. Only that it took time for the law to get to cabinet. The bills stagnated at one point. So this was not even politically motivated. It was initiated by the Law Commission in a wider review of the laws regulating the police. And this is one of the proposals that was made, and even a bill emanated from that institution. It was not even government that introduced that provision. But government looked at it, and government was satisfied that it complies with applicable international law regulating such kind of searches, because I think a lot of research was done in other jurisdictions, and we found that this is acceptable as long as it is regulated the way it was regulated. In our folder, we had a document. I'm hoping that document is also before the committee explaining this provision. Mr. Kaira can confirm that, which has gone to length to explain why Malawi government took this move, and also the justifications. They are all in there. The other issue that was raised, I think, relates to the conflicting information on the separation of remandees and convicts. I will invite Mr. Kaira to comment on that as well.
Thank you, Chair. I'll start with the question on the separation of remandees as well as sentenced prisoners. The constitutional requirement is that these two groups should be separated, and I think the state party has made efforts to ensure that this requirement is followed. However, there are instances where, due to lack of space, remandees and sentenced prisoners have been held in the same place. But I want to emphasize that the state recognizes that international standards as well as our own constitutional standards require us to separate them. So the efforts are there that these two groups should be separated. I'll also comment on the issue of the searches without a warrant, as raised in issue number 15. I think we gave what we thought was a comprehensive response to this. Firstly, to highlight that this is an exception to the general rules that searches should be conducted with a warrant. And this exception is accompanied by what we think are quite firm conditions which are to be followed by the police officers to conduct those searches. So just in answering some of the questions which the honourable member raised about whether it is always urgent for such searches without a warrant to be conducted? The answer is no, it can't be always urgent. As I said, it's an exception to the general rule, and this provision essentially applies to only those exceptional circumstances where it is really, in the view of the law enforcement agencies, very urgent for a search to be conducted without a warrant. There was also a question whether there have been any complaints that maybe those conditions in Section 35 have not been followed. We are not aware of any such complaints. If there are any, or if there were to be any, they can be taken before a court of law to address those complaints. There was also an issue on whether this could be used for purposes of harassment. The intention of that section really is to take care of instances where it may be really necessary to conduct a search without warrant. So there was really no intention of harassment, and as far as we're aware, we are not aware of any instances where that has occurred. The final question was whether it complies with Article 17 of the Covenant. With our explanation here, we are convinced that it does comply with that Article 17. The right to privacy is provided for in the Constitution, but we have also said that it's not an absolute right. It can be limited, and there are clear instances, legal instances, where that limitation applies. So we are of the view that it does apply with Article 17. Thank you.
Thank you very much. Moving on to the next issue. There was a question about how government shall roll out the prevention efforts. This is in relation to HIV and AIDS while marginalizing homosexuals, and also the status of the HIV/AIDS bill. The way the bill is framed at the moment, it's very difficult to appreciate how it would marginalize homosexuals, because it's all encompassing, and I think it's supposed to prevent HIV/AIDS for all sections of society, and also manage the epidemic. In terms of the status, the bill has been delayed because of, I think, ill-conceived, what I would call ill-conceived consultations. I refer to them as ill-conceived because this bill was initiated, I think, through the Law Commission by the department responsible for HIV and AIDS nutrition, and also the state institution, NAC, National AIDS Commission, which is also mandated to deal with the issue of HIV and AIDS. There was a highly consultative process involved in coming up with a report of the Law Commission, the Special Law Commission that was constituted to do the review. They had meetings in all the districts, in all the regions, and even at national level. And they even conducted study tours to, of course, developed countries, but also countries within the region, just to understand how other countries are dealing with the issue of HIV/AIDS from the perspective of legislation. So the Special Law Commission submitted its report to the Minister of Justice, and just when the report was about to be discussed at cabinet level, and then other consultations started again. But your committee should appreciate the fact that these consultations involved civil society, and from the word go, even people living with HIV and AIDS were part and parcel of the process. Even the forums where they were consulted, it wasn't just across the board. They were targeted, and then there were the general forums. And they were very happy with the recommendations that were made in that bill. But now the bill has stalled, it has delayed because there are these other consultations that have come up. And now the decision for government is whether to go by the law, which requires that once a report from the Law Commission is submitted to the Minister of Justice, it should be laid before cabinet, wholesale, the way it was submitted. And then you can have these other amendments or proposals being presented to cabinet so that they can amend the bill if there are any shortfalls. Or just to start all over again and remove, as it is being proposed at the moment, a big chunk of the bill and just focus on the institution that is supposed to manage HIV/AIDS in Malawi, just the institutional structure, because that is the proposal that is being made now. So we are at that stage. But the position of the Minister of Justice as the since the Minister of Justice has the report, is to take the report and the original proposed bill to Cabinet, so that then the policy ministries can now bring in these other proposals that are being done now. I'm highlighting this because I think the issue was the way we responded in the issues of the list of issues, I think, was very brief and wasn't very informative. Just said the consultations have taken place and the matters are being addressed. They are addressed in the context that I'm explaining now. So that is where we are on the issue of that law. Moving to the next issue, it was about the status of the outcome of the Commission of Inquiry regarding, I think this is the 2011, so I would defer to Mr. Kaida, Chief State Advocate, to respond on the lessons that we have learned from this report and what recommendations have been used, the specific recommendations that have been useful to promote peaceful, I think, assembly in Malawi.
Thank you, Chair. On the July 20 Commission of Inquiry, which, as we've said in our report, presented its findings in July 2012, the Commission made quite a good range of recommendations, specific recommendations to specific institutions, such as the organizers of demonstrations, firstly, secondly, to the police service on how they can control demonstrations, as well as to the executive, and then also to the media on how they can be covering issues of demonstrations. So just to highlight what recommendations were given to the organizers, I think one of the challenges which we had with the July 20 demonstrations, which descended into all the chaos that resulted, was that there was quite a high level of ignorance on part of both the organizers as well as the police on what the law said as far as organizing assemblies and demonstrations is concerned. The law which governs demonstrations and assemblies in Malawi, firstly, is the Constitution, but the enabling legislation is the Police Act, and it has very detailed procedures which have to be followed by organizers, which have to be followed by the police, which have to be followed by city assembly officials on how to organize demonstrations. So in terms of July 20, the first lesson is that most of these procedures were not followed by either the organizers or even the police themselves. So the recommendations essentially highlighted to the organizers to say that they have to follow what the law says. For example, to give appropriate notice to the civil authorities as to when they wanted to hold a demonstration. To the police, the recommendations essentially homed in on the issue of how to control the crowds, which was a major challenge as far as July 20 was concerned. The recommendations also touched on the use of force. Clearly, on July 20, there was maximum, not maximum, but maybe excessive use of force. And the recommendations really also touched on how the police can use appropriate force to control the crowds. The media was also given a few recommendations, such as not to sensationalize the coverage of issues to do with demonstrations. Because the challenge we had with July 20 was that it was felt in some quarters that the media was a bit too sensational, and the Commission of Inquiry has also highlighted those issues. And broadly, as what have we learned from this, as we said, I think yesterday, is that since July 20, we have had demonstrations which have passed on very peacefully, and I think that is a result that all the key players, starting with organizers, the police and the media, they have worked hand in hand. They have taken on board some of the recommendations of the Commission of Inquiry to ensure that these demonstrations are very peaceful. That's the major lesson we have learned from the Commission of Inquiry. In addition to that, following the report, the police have conducted several crowd control training sessions to essentially teach officers on how they can handle crowds in line with what the Police Act says. So briefly, those are the lessons we have learned from July 20. There was also a question on the challenges, I think in reference to paragraph 72 of our report, which talks about challenges in ensuring the enjoyment of this right. I think the challenges are what I've just said, to say that in relation to July 20, there wasn't that much knowledge about what the law said on what various key stakeholders the role they would play in terms of organizing the demonstrations as well as regulating the demonstrations. So those were the challenges which we were essentially highlighting in our 2012 report. Briefly, that's how we would answer this question. Thank you.
Thank you very much. And I think just to add to that, there's the flip side of the coin in terms of the enormous challenges. In practice, what has transpired is that people start out as peaceful demonstrations, but sometimes it happens that they have a hidden agenda, and the police are ill-equipped to react in those situations. You find that the crowd can all of a sudden become so hostile. So that is a challenge for the police. And as a Minister of Justice, government is struggling to settle, not even just to settle, even defend matters in court where people are suing government left, right, and center on cases of riot damage. So it's a matter that we are also looking into in terms of how best the law can address that, and whether the law that we have in that area is adequate to help the government, I think, deal with those situations. I think moving on to the next issue, I think it was to do with the plans of government in terms of dissemination of the ICCPR, especially the conclusions of the Human Rights Committee. And before I defer to my colleague, I think just to mention that on our part as a policy holder in this area, we'll make sure that this report and the conclusions are brought to the attention of Cabinet at that level. In terms of rolling out the program, I think there are other issues, there are other activities or issues that we are going to do as a government, but in consultation with the other governance institutions in Malawi, which are also involved in making sure that the ICCPR is implemented in Malawi or respected. So I refer to Mr. Nyirongo on that one as well.
Thank you, Chair. I think with respect to this particular report, the ICCPR report, this is the initial report, so there's never been any process subsequent to this process. But learning from the practice with respect to the other instruments that Malawi has been reporting on, Malawi intends to also replicate the same processes which are used with the other instruments by actually compiling the full set of the dialogue, which commenced with the presentation of the initial report, the responses from the committee, which were in the list of issues, and the responses and the concluding observations. And the way it is done with respect to the other instruments is that the responsible state agency or ministry is the one that starts putting the stakeholders together to report on the process which started the reporting process and the engagement with the committee, and then tell them that about that process and what was concluded, so that it can also inform the development of the next report. We believe that with the presentation of this initial report, Malawi needs to make sure that it is not only developing the reports when they are due, but it's a continuous engagement process with all stakeholders to ensure that all parties are participating and that the process does not actually end with the presentation of the report, and that those who were participating in the development of the report are also given feedback on what that process led to, so that these processes are not just for the benefit of the Human Rights Committee, but for the enjoyment of the rights within the state. Thank you.
Thank you very much. The other issue, I think, concerned the delays in enacting upwards the age of marriage. I think we already appraised your committee on the challenges that we have on that, but we have taken note of the concerns as a government, and I think we'll make sure that we'll try to expedite the processes that are taking place now to see how we can go around the constitutional hiccup that we are facing at the moment. And also, I think there was the issue of tensions between Christians and Muslims in Mangochi. We have taken note of the recommendation of your committee for government to sensitize people on their religious, rights. The other issue was on sexual abuse of children, whether the protection of the rights of the child in terms of sexual abuse extends to boys, and what measures the state has put in place to defend the abuse of children. I would defer to Mr. Nyirongo on that one to respond.
Yeah, thank you, Chair. I think with respect to the two issues of prevention of sexual abuse of children and also whether there is specific protection of boys, I think with respect to the Penal Code, there's provision on defilement of girls. And in that regard, the age of a child has been raised from 13 to 16, according to the 2010 amendment. But in the same Penal Code as amended in 2010, there's a new chapter which we referred to yesterday with respect to offenses against morality relating to children. In that chapter, chapter 15A, sexual activity has been defined. And it is defined with respect to children, and there's even specific mention that the definition of sexual activity is regardless of the sex of the child. So sexual activity applies to both boys and girls, and under that chapter, a child is also recognized as a person below the age of 16 years, and there are several prohibited sexual acts which apply to both girls and boys under that provision. So in terms of whether there's like a bias towards protection of girls, with the introduction of this chapter in the same Penal Code, there's now protection for both boys and girls. And with respect to prevention, I think there have been quite a number of steps beyond just the Penal Code provisions under this chapter, and also with respect to defilement. We've got other legislation. We referred to yesterday to the Prevention of Domestic Violence Act. It specifically mentions criminal activity within the domestic environment, and part of the abuse which has been identified as domestic violence is sexual abuse. So under that statute, we also have got that recognition, and the whole machinery of the Prevention of Domestic Violence Act also applies with respect to protecting children. Then there is also the Child Care Protection and Justice Act. I think by the very title, we're talking about care and protection of children, and part of the protection extends to sexual abuse against children. So there are provisions that have been introduced. The other thing that the Child Care Protection and Justice Act also does is to create child justice courts. These are special courts that are dealing with issues of children, and the administration of justice is not the way it is done in the formal courts, as it were, the magistracy and the High Court. Here the rules are a bit flexed because of the subject matter of the courts, which are children, and we also have got different rules of evidence, and there are also processes of diverting children, and there are also restrictions on how the media can report on the matters that are actually handled by these courts. So all those are facilities which have been introduced to make sure that in the event that the prevention fails and the abuse occurs, when the children are taken through the child justice system, they are also protected in terms of their identity, and also through the process which they actually tender evidence if they have to, or indeed participate in another process in these courts. So these are some of the measures that are being taken to make sure that children are protected. But complementary to this, there are also other administrative arrangements. I think our colleague, Mr. Shinyama from police, also indicated that the police as an institution has got child protection officers at almost every station. These are people who are supposed to also assist in actually leading the prevention processes, which include awareness and education where there's need, and also encouraging communities to make sure that they are protecting children. With respect to the community victim support units, these are established with traditional authority. We have got traditional leaders who are also participating in the process of making sure that children are actually protected from abuse. So their roles, whether they are traditional leadership or the police, would be to actually sensitize people on identification of cases of abuse and responding to those cases so that they are brought within the justice system, and where it is applicable, through the child justice system, which is friendly to children, so that children are able to participate in the event that the abuse has occurred. Thank you, Chair.
Thank you very much. I think the other issue that was raised relates to I think there was an example of a case that was given about a girl that was defiled and infected with HIV and AIDS. This is the first time we are hearing about this matter. So it will be very difficult for us to respond today, but we can promise that when we go back, we can look into this matter and find out what really happened, especially in relation to the concern that the judiciary are complicit in whatever happened. But I think we'll carry out investigations when we get back. Then there was also the issue of, I think there was, we've been asked to give a list of offenses attracting, that may attract a death penalty. We'll compile that list and submit it to your committee, just to give an indication of the direction that Malawi has taken. There are two more issues which I think we'll need time to discuss as a delegation. There was the issue of the Disability Act and a number of questions that were raised in relation to that act, in terms of how the law has been executed, the fund, whether it's functional, whether there are civil remedies for violations. Can one sue in case of government to provide services, whether there's a specific board monitoring implementation of the act. That last aspect, government has just set up a committee, like an advisory board, to monitor the implementation of the act. And I know I'm a member of that board, but this has been recent. We are yet to start meeting, I think as recent as last month. So there's that body that has been set up to monitor the implementation of the act. But in terms of the other specific issues, oh yeah, my colleague was just reminding me that even the Human Rights Commission, they have a directorate to deal specifically on issues relating to people with disabilities. So I think there are efforts across the board, but we just need to sit down and look at what is there and then give a concrete answer, I think at a later stage. The other issue that we're also not able to discuss in the 15 minutes that were given is the issue relating to access of information. I think the concern about libel being both criminal and civil, and also the issue of detention of journalists, why this is still happening, and the status of journalists who were arrested, but also we were requested to give complete information on the list that was submitted in our report. We still need to consult as a delegation on these issues. So these are, I think, basically, there might be other issues that maybe we have skipped, but these are the issues that I can recall that we have not been able to respond at this session because of the time constraint. Thank you, Chair.
Thank you very much, Dr. Banda. I guess I should make clear that the purpose for the consultation is not for the delegation to be able to decide what its answer should be, but to be able to organize who answers what. The assumption is that the delegation has the information in terms of its overall composition. Otherwise it would be clearly impossible in 2 meetings of the committee to allow every delegation, and some are substantially bigger than this one, to organize their, to determine what the responses to the questions would be as part of the consultative process during the dialogue. Now, final round of follow-up questions, colleagues. And the first person I see is Mrs. Vattenfall. You have the floor, ma'am.
Thank you, Mr. Chair. I thank the delegation for the answer. I just think that I missed the answer on the corroboration rule, which is applied in court. The corroboration rule, when people need a witness to prove that a certain act was happening. Thank you.
Thank you, Ms. Vattenfall. Mr. Flinterman, you have the floor.
Thank you, Mr. Chairman. I would like to thank the delegation for the responses given so far, especially also on that important issue of the outcome of the Commission of Inquiry. I very much appreciated the survey of the lessons learned by all involved stakeholders. One element of my question relating to that Commission of Inquiry has not yet been touched upon by the delegation, and that is the lack of prosecutions of those responsible for the killings. And I'm raising that because it's also an issue of great concern. I noted in Malawi itself, I'm quoting from a newspaper article where it is said that the delay in prosecuting those who were responsible for the July 20 death is disappointing, and it's equally disheartening that the police and prosecution authorities have not proactively provided information to the public on the reason for the delay. And I would like to invite the delegation to share with us what the reasons are for the delay and whether any prosecutions may be expected. Thank you once again for the responses so far.
Thank you, Mr. Flinterman. The next speaker on my list is Mr. Kalin. Mr. Kalin, you have the floor, sir.
Thank you, Chair. Coming in at such a late stage, I would like first to join my colleagues in warmly welcoming the delegation. Because we have some time left, I would like to take up an issue that was not discussed thus far, but that is relevant, and that's issues related to the prohibition of non-refoulement under Article 7 of our covenant. Information in front of us indicates that while Malawi has a refugee status determination system, no decisions have been taken since December 2011, meaning that several thousand cases are still pending. And we usually have concerns with such delays because in such situations there is a danger that people who are in fact refugees will be sent back to their country of origin. We also have some information that in a few cases, but still in some cases, either entry of asylum seekers was denied or they were sent back to the country of origin with the argument that their countries were not at war. Of course, according to the covenant, people can be endangered and have risks to be exposed to ill treatment, even if the country is not at war. And I very much would like to have some comments on these issues. Coming in so late, I would understand if you wouldn't have the answer right now and that you would provide it in writing in the follow-up to this meeting. Thank you.
Thank you, Mr. Kalin. Mr. Vatslashvili, next speaker on my list. You have the floor, sir.
Thank you very much, Mr. Chair, and I thank the delegation for those responses which have been provided. I realize that there are some issues which will be communicated later on in writing, and very much looking forward to those answers. But let me briefly touch the issue of the broadcasting as far as there was a response, just to clarify and to receive a more comprehensive information. It was very encouraging to learn that there are almost 16, I think, or 15 or 16 broadcasters licensed. I assume that they were local or community, or local private or community broadcasters. Actually, I was referring to the national broadcasters, those who have a national coverage. And to best of my knowledge, there are only, apart from public broadcaster, there are only two names are MBC and TVM. And with regard to those broadcasters, that's what I read from the reports. With regard to those broadcasters, there have been reports that there is the role of the state in appointing the board of those broadcasters is quite an excessive. So that will be very useful again to learn. And with regard to the e-bill as well, apart from we've learned that the bill is still on the table and is still being considered. And the reasons why I raised the issue was that it's because there were concerns voiced that the bill may actually impose some limits on the freedom of expression, especially on online media. So the assurances of delegation will be really welcome that all those concerns will be taken into account during the process of elaboration of this bill. Thank you very much.
Thank you, Mr. Vasilashvili. Mr. Bouzid, you have the floor, sir.
Thank you, Mr. Chairperson. I thank the delegation for the answers provided so far on the questions I raised, but I did not hear anything yet with regards to the phenomenon of the street children living in the street. Does the government have any information about the importance of this phenomenon? For example, the number of children concerned. Has the government established centers to care for those children? And can we know the number of children that are impacted by this phenomenon? Is the phenomenon increasing in its importance or decreasing? Thank you, Mr. Chairperson.
Thank you, Shukran Said Bouzid. I see no more hands. I'll allow myself then a little bit of follow-up. Grateful for the response from the head of the delegation that reports of the National Commission and I presume the Inspectorate are laid before Parliament. I'd be interested to know if any have actually been laid before Parliament and what kinds of reports. Are they annual reports? And are they available to the committee, for example? The issue of the lessons learned from the July the 20th demonstrations, the Police Act apparently indicates when the police can and can't use force. It would be very useful to have that information as to under what circumstances they can and can't use force. This committee tends to interpret Article 6 of the Covenant in the light of the UN Basic Principles on the use of force and firearms by law enforcement officials. And they're very clear. The fact of an unlawful demonstration doesn't justify the use of lethal force or even potentially lethal force. Potential lethal force may be used to protect life and limb. Lethal force may be used, if absolutely necessary, to protect life. So it would be useful to know how far the Police Act does, in fact, reflect those notions of proportionality, substantive proportionality, that are essential to avoid any recurrence. And, of course, to the extent that the law already forbade such use of force, and I heard the distinguished delegate talk in terms of accepting that there was excessive use of force. If it was excessive under the law, what measures have been taken against those who actually used excessive force, which resulted in deaths? And finally, from me, the issue of I didn't hear a response to my question about whether there have been actually any claims for false imprisonment for people who've been detained in prison beyond the periods when they should have been detained. Have there been any suits? Has there been any reparation awarded? It may be that the information isn't with the delegation right now. I make the point, and I'll make it again in a little while, that of course there will be 48 hours for the delegation to provide any information it isn't able to provide orally, to provide it in writing, so that it can be taken account of in our concluding observations. So, but these are questions that it would be valuable to have information on. So finally, I turn back to you, Dr. Banda, Distinguished Head of Delegation, to respond to the extent that you feel able to, you and your delegation, to that definitely last round of questions from us. You have the floor, ma'am.
Thank you, Chairperson. I'll start with the last question on whether there have been claims on forced imprisonment. I can confirm that the Ministry of Justice at the moment is inundated with such claims, and most of these claims we just settle out of court because you find that government has no defense, and perhaps the police acted illegally in those situations. But as a ministry, we have also moved further to require that the police should discipline officers who are involved in these cases as a way of trying to curb and also to help government mitigate loss of resources, because there are a lot of cases and people indeed claim for forced imprisonment. We can supply statistics, I think, later, in terms of the workload that we have just on the police and on the cases of forced imprisonment. That should not pose a problem. On the question of under what I've started, I think, responding to the questions from the bottom up. The question on whether or under what circumstances can the police use force, and the measures that have been taken place, that have been put in place to prevent the use of excessive force, I would defer to my colleague, the Deputy Inspector General of Police, to respond to that issue.
Thank you, Chair. Our leader of delegation, Chair, thank you very much. As we said yesterday, we did explain on this issue of use of firearms in accordance with the Police Act. The question here is when and how do Malawi police officers, or does the law allow Malawi police officers to use a firearm? There are several instances where police officers are guided to use a firearm. As you already alluded to, Chair, one of the instances when the police are supposed to use a firearm is when a person's life is in danger, or someone who has committed a felony is escaping from lawful custody. But in essence, the use of firearm entails that a policeman is not supposed to kill, but to disable. But as well, we are all aware, this is a mechanism. A firearm is a mechanism, operates from a mechanism, and sometimes it's difficult to control. We find ourselves in the situation that we are talking about here. But in essence, our mode of operation is to disable any suspect but in special circumstances, as I highlighted, Chair. What we are also saying, maybe the question about the demonstrations, as explained by the previous speakers, on the need for us to interact and operate within the dictates of the law within Malawi. We are saying the 20 demonstrations incident gives us more lessons to learn from. And in response to that, as police, the Malawi government has made sure that the police operate within the dictates of the laws in as far as the demonstrations are concerned. Because Malawians have the right to demonstrate, and there is no need, and the police have no powers to stop them. But perhaps what was lacking is the issue of interaction and negotiations before the events take place. So really what we are saying is, as police, the Malawi government is keen to make sure that the police operates within the dictates of the laws, the Constitution of Malawi, as well as the dictates of the Police Act. Thank you, Chair.
Thank you very much. Moving on to the next issue. The question was about the reports of the Human Rights Commission and also the reports of the Inspectorate of Prisons, whether we're referring to the annual reports. I can also confirm that mostly these are annual reports, but they also produce ad hoc reports depending on the issue at hand. The annual reports are very informative in terms of detailing the work of these institutions and the challenges and also the recommendations that they make. And they're very informative to the, I think, relevant authorities. Just to highlight an example, there was a problem of cooking for prison populations. And I think a recommendation from the Inspectorate of Prison was that the prisons need electronic cooking pots. And government, in collaboration with the EU, managed to secure those pots, and now they are installed in all the prisons in Malawi. So now they don't have to use firewood to cook for prisoners. It's all electronic. But this emanated from a report, a recommendation of the Inspectorate of Prisons. This is why we're saying that some of the reforms that are taking place in the prisons actually originate from these kind of reports. Even the Human Rights Commission report, we recently had the issue of Cashgate in Malawi. Some of the recommendations that they made have found their way in the DPPs, in the prosecution process that is taking place now, the investigations and the prosecutions. But this also came from the Human Rights Commission. Those are just the examples that I could give in terms of the relevance of these reports and also the impact that they are having on government. Moving on to the next issue that I think that has been raised. I think the question was about the number of children in the streets and measures to protect, whether there are measures put in place to protect the numbers, to reduce the numbers, and whether in terms of statistics this is working, whether it's decreasing. The Minister of Gender, this is an issue that has been with the Minister of Gender for some time. They're trying to establish statistics, official statistics of a number of children on the street, but they're also working with NGOs like, I can't remember the name of the NGO, but to try to keep...
National Statistics.
No. What they're trying to do is to find ways of working with the NGOs to keep these children out of the streets. there's actually deliberate effort to that effect. Yeah, the NGO is SOS. I've just been reminded. SOS. And I think they've been trying to get the children from the streets and work with SOS and keep them in homes managed by SOS. Now, I think the initiative, they're trying to see how government can also sponsor the management or contribute to the management of those homes at the moment, just to help with the problem with the street children. In terms of the details, I think the other measures we can provide later, but those are the initial, I think, efforts that are being done from the perspective of the Ministry of Gender. The other issue that has been raised is to do with the collaborative rule from the distinguished member, and also the concern about lack of prosecutions. And I think we've been asked to explain why there are all these delays in prosecuting, I think, people who commit these offenses under the, I think that so I'll ask Mr. Kaira to respond to the issue, I think, because this is criminal. Yeah.
Thank you, Chair. I'll start with the collaboration. I take it that the question relates to the requirement for corroboration of evidence in sexual offences. Yeah, we have a rule of procedure as far as evidence is concerned in the prosecution of sexual offences that there is need for corroborative evidence, and this evidence can be in the form of another witness testifying, or the court looks at the totality of the circumstances of the case to establish whether indeed a sexual offense was committed. So this requirement is in terms of procedure as far as evidence, the giving of evidence is concerned. The second question on Commission of Inquiry, in relation to July 20, in our report we have also highlighted the grade of the events of July 20, and there has been a delay in prosecution. I think it was also mentioned yesterday that some arrests were made, several people were arrested, but when the police produced the case docket, they sent it to the Director of Public Prosecution. It was sent back so that certain elements or areas of the cases should be further investigated. So that essentially has delayed the process of prosecution. But as a state party, we just want to highlight that there is commitment that those people who committed these acts should be held responsible and accountable for these acts. Thank you.
Mr. Chair, moving on to the next issue that was raised to do with the national broadcaster. I want to mention here that, and of course in relation to the bill on access to information, that there is political will to move this bill forward. I can assure, as a leader of the delegation of Malawi, I can assure the distinguished member that there is political will. Actually, the new government and the new president in the State of the Nation address confirmed the desire of this new government to move this bill forward as soon as possible. So that is on the program already. And then in terms of opening up of the airwaves, especially of the national broadcaster, Mr. Chair, your committee may wish to know that MBC now is under so much pressure and competition from a private radio station, which also has national coverage. This is Zodiac Radio. And Zodiac Radio also obtained a TV license recently. And you may be aware that even during the elections, the Electoral Commission, which is a state institution, chose Zodiac as the official broadcaster of results. So that puts pressure even on MBC. Apart from the fact that MBC is now opening up, there's also this competition to balance and also to ensure that there's a balance in terms of its own programs. And I think we have seen so much progress We have made so much progress, especially in the last election, that even opposition leaders would be covered, which was a thing that couldn't happen in the past. So it's a process for us as a country. It's a process, it's a transition, but we know that at least we are getting where we are supposed to, we've taken the direction where we're supposed to go. Moving to the other issue that has been raised is to do with refugees, and I will defer to Mr. Nyilongo to respond to the status of the Malawi system on refugees and whether indeed no decisions have been taken since 2010 and why, 2011 and why.
Okay. Chair, with respect to the issue of refugees and asylum seekers, government acknowledged that indeed there was a backlog, and this year the Chief Secretary to the government did direct that by the end of the year, that backlog must be cleared. So in response, government established a committee that is now making the assessments and clearing the applications for either refugee status or those applying for asylum. And as of now, that backlog is almost done, but I think it will be properly concluded at the end of the year, so that this is also taken, we are now clear for fresh applications. But over and above this initiative, government is also trying to develop a new immigration policy to take into account the issue that was raised with respect to the reasons that people offer for seeking asylum, so that the policy can also guide legislation which will be developed. We do have an Immigration Act, we have a Citizenship Act, we also have a Refugee Act. But these statutes are now substantively old, and there have been a number of developments in this area of migration which need to actually have legislative force. So the development of the policy is supposed to inform legislative reform, so that these statutes which are in place are also responsive to these developments and are actually relevant to the needs and aspirations that have arisen in the meantime. I think that said, I think that answers that question. Thank you, Chair.
I guess we have to wind up at this point just because we're hitting 1 o'clock. So any responses that the delegation hasn't had a time to make, it can make it in writing within the next 48 hours. And I'll say a little bit more about that in my own wrapping up. But now we come to the point at which I invite you as head of delegation, Dr. Banda, to say any last words you wish to say to the committee. You have the floor, ma'am.
Thank you, Chairperson. On behalf of the Malawi delegation and also on behalf of the Malawi government, let me take this opportunity to thank your committee for inviting us and for the, I think, useful engagement that we've had and the opportunity that we've had as Malawi to appraise your committee on the developments that have been taking place in Malawi. As you're aware, this was our first report. A lot of information had to go into this report, being a first report. We know there's a lot of outstanding areas, issues where we're supposed to provide information. I think statistics and the other issues that I think 2 or 3 issues that we have not been able to respond due to time constraints. We make an undertaking that we'll be able to provide that information as soon as possible. But we are very grateful for the fruitful engagement and I think the useful questions and insights from your committee, which will also, I think, help us when we go back to look into the other areas perhaps where we have not done well and find ways and means of trying to improve and promote and safeguard the enjoyment of civil and socio-political rights in Malawi. I think with that brief concluding remarks, I thank you and wish your committee fruitful deliberations, continued fruitful deliberations. I've seen that your calendar goes up to the 25th or 22nd. I thank you, Chairperson. Thank you.
Thank you very much, Dr. Banda. It's been a genuine pleasure at last to have a delegation with an initial report and a delegation so well placed to be able to provide a lot of information that we needed. And we are all aware of how far Malawi has had to come from a period of what I believe you called a dictatorship, and it has come a long way, there's no doubt about it, in terms of openness and respect for the fundamental freedoms and so on. But there remain the problems that you've heard from colleagues that have been raised in the list of issues, everything from excessive reactions to demonstrations, restrictions on criticism of various sorts, both within the press and through human rights defenders, that are going to be, I think, of concern to the committee. The various social issues have been discussed, which raise issues for the committee, all of which the delegation is aware of and has explained. The developments, some stymied by changes in administration and so on, that will need to be addressed by the committee in its concluding observations. The delegation has undertaken to provide certain materials, and I would urge it to do so within the 48 hours that are available to the best of its ability. Ones that I would encourage also be included, if they're not already intended, would be, first of all, say, copies of the most recent examples of the reports laid before Parliament by the Prisons Inspectorate and by the Ombudsman. The questions weren't so much about relevance as about availability, and I'm still looking for some evidence that these reports are genuinely available to the public, and perhaps by making them available to the committee, that would be evidence that they are. It would also be useful to have the relevant information from the Police Act relating to the use of force. It was very helpful to have the information that Mr. Kanyama gave. I couldn't help but raise a metaphorical eyebrow at the idea that a felon who is escaping from custody may be the subject of potentially lethal force. Felonies contain a wide range of events that don't always present a threat to life and limb. In the absence of a threat to life and limb, the use of potentially lethal force is a problem. So it would be very good to have the information on that, so that committee is then in a position to make properly focused recommendations to the state party. So with that, I thank the delegation for its hard work, its dedication, its responsiveness, and look forward to this being indeed part of a continuing dialogue, both in terms of the information that will be made available to us within the next 48 hours, and of course in terms of the standard follow-up procedures that the committee follows. With that, I once again thank the delegation, wish it safe home, and thank also the interpreters for yet again indulging us for the few extra minutes we've taken. And so with that, I suspend the session. Any announcements, Case? Sorry, there's an announcement from
Apologies.
Secretariat.
Thank you, Mr. Chair. Just to remind the members that there will be the NGO briefing on Georgia at 2 o'clock in room RS 181. Thank you very much.
The meeting suspended.